All right, we have an excellent set of speakers lined up for you today. Christina Hall is the Chief Human Resources Officer for Instacart and oversees the company's human resources, recruiting, workplace culture, employee, and D&I functions. Prior to joining Instacart, she served as Chief People Officer at LinkedIn and previously held key human resources roles at Facebook and Intuit. Pam Carlin is the Kenneth and Harl Montgomery Professor of Public Interest Law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. Pam is one of the nation's leading experts on constitutional law, voting, and the political process. She has served as a commissioner on the California Fair Political Practices Commission, an assistant counsel and cooperating attorney for the NAACP Legal Defense Fund, and a deputy assistant attorney general in the Civil Rights Division of the U.S. Department of Justice. David Sutphin is the founder and co-CEO of Jasper Advisors. David is a lawyer by training and began his career in civil rights before practicing law at Covington and Burling and entering politics. He worked as chief of staff to Congressman Harold Ford Jr. and Judiciary Committee General Counsel to the late Senator Edward M. Kennedy. Marina Satalis is a partner at Wilson Sonsini, Goodrich & Rosati. She regularly advises and represents the world's leading technology, communications, pharmaceutical, and life sciences companies in significant employment and trade secret matters. Today's session will be moderated by Joe Grunfest, the W.A. Franke Professor of Law and Business Emeritus at Stanford Law School and senior faculty of the Rock Center for Corporate Governance. Before joining the Stanford Law School faculty in 1990, Joe was a commissioner of the Securities and Exchange Commission and served on the staff of the President's Council of Economic Advisors. Welcome, everyone. Joe, I'm going to turn things over to you to get started.
Thank you very much, Kristen. It's a terrific panel we have. And again, we're going to be talking about race, religion, and the corporation. What could possibly go wrong? We're going to focus on two Supreme Court opinions. The first that's gotten a tremendous amount of attention, the affirmative action cases involving Harvard and the University of North Carolina. The second, Groff versus DeJoy, a case that you'll hear probably has gotten far less attention than it deserves, raises just as many fascinating questions as the major affirmative action case. And both of these cases taken together suggest that we're heading for a brave new world of various forms of employment-related litigation involving just about every conceivable corporation and every conceivable fact pattern that might come to mind. Let's kick it off with an open-ended discussion about the affirmative action case. And Christina, let me turn it to you and let me just ask you the following two-part question. Which questions are coming up from your perspective that are going to be most troubling for corporations when it comes to thinking about the application of the Harvard and North Carolina cases to the corporations? And what advice would you be giving corporations with regard to how to respond to those difficult challenges? So part one, what are the challenges? Part two, what are the responses you're giving people?
Well, right now, I think the question that I'm getting the most often is, does this change everything? You know, are all of these efforts and plans and progress that we've been trying to make regarding diversity, equity, and belonging at a company like mine and so many others, like, is that dashed now? Or are we just, throwing that out because of this case? And the answer that I think I am giving, and I think most people like me are giving, is hold your horses. We still have a really important commitment to diversity, equity, and belonging in the corporation, and we need to continue to pursue those goals. Nothing about this specific case touches us directly at this point, and I think that we can still do the good work we need to do, just in being thoughtful how we execute it.
When you say being thoughtful in terms of how we execute it, can you give me an example of thoughtless and thoughtful execution?
I think thoughtful is to make sure that you're not drawing arbitrary lines around who can participate in activities that might benefit different diverse individuals, but could be inclusive. So, for example, we have employee resource groups of various different types to represent Black employees or to represent other diverse groups, but we allow anyone someone to join those groups who feels an affinity towards it. And we try and be inclusive, even though the actions that and the focus of some of those groups may be specifically, tailored or beneficial for a named group, but we don't exclude anyone out.
David, what does it look like from your perch?
So first of all, appreciate being part of the conversation. The questions that I'm getting, similar to what Christina was saying, do we have to worry about our hiring practices? Do we have to worry about our philanthropy? Do we have to worry about our talent development pipelines? And, I think the advice that I'm giving clients, as alluded, I used to be a lawyer. I don't practice one, not a practicing lawyer, is I think this is one of these moments where the interplay between law and communications matters a lot. So for example, on questions of philanthropy, there's a lot of companies in the wake of George Floyd's death in 2020 made very explicit commitments to support work around the Black community. A lot of that's philanthropic. I think the perspectives that I've heard from, very talented civil rights lawyers like Pam in the past are, if it's your philanthropy, you probably need to be less concerned about the decision because, philanthropic efforts are one thing. But if you've got a specific mid-career talent development pipeline program that's focused exclusively on Black employees or some other historically underrepresented group, you may need to think about the structure, the form of that program. I think there's been a lot of discussion about the need to take a step back, audit the various initiatives, efforts you have, look at language. And then the other big takeaway that I've been hearing is, prior to the use of the concept of diversity, a lot of this was a discussion about, anti-discrimination and Title VII. And so I've heard a lot of people talk about the need to go back to talking about some of these efforts to diversify your workforce through the prism and language of compliance and Title VII adherence, because the reality is most corporations in these days still have significant underrepresentation when it comes to Black employees, Latinx employees, women. And so a lot of these efforts are designed to deal with and ensure that companies are actually complying with the law, as opposed to maybe running afoul of the Supreme Court decision.
Well, let's drill down. Let's try to take the specific hypothetical here. Let's assume you've got a company that measures the race and ethnicity of its employees at various levels. And let's assume it finds that 5% of its management level employees at a certain tier are Black. And it has an internal corporate objective of we want to get that to 10% and we want to do it within the next 5 years. Is that problematic in your view with regard to the recent affirmative action cases?
Is that directed to me, Joe?
Sir.
As you said, there's some of these hypotheticals are complicated. I would ultimately defer to the true lawyers on the call, but my instinct on that is it probably depends in part upon how people are measured for that. So like if there's, it's tied to your pay, that might be more complicated. If it's a role that historically has never had a person of color in that job, I think that probably gives you a little bit more flexibility in having targets and goals, because ultimately, and I find this somewhat ironic, you heard my introduction, I obviously worked for Senator Kennedy, but there was an article in the New York Times, I think yesterday or last week, and in Axios about how, the Republican Party is trying to recruit more diverse candidates to increase its representation in the House. So the reality is everyone, regardless of your political affiliation, most people are looking for ways to bring more diversity into their workforce. So I would surely hope that the true lawyers on the call would not tell us that having goals is no longer allowed legally.
Marina, as a true lawyer, what do you see? What questions are you getting? How would you respond to that hypo?
The kinds of questions I'm getting are, back to the beginning of our conversation, is my DEI program still okay to have? And many clients are going back, and I think rightfully so, to review their DEI program and initiatives, since there seems to be this, almost hostility, right, at least by a majority of the Supreme Court to what we saw in terms of the programs for admission at Harvard and at North Carolina. But I would say, and echoing what the others have said so far, a properly crafted DEI workplace program really shouldn't be impacted so much by the new ruling. Under Title VII, it's unlawful to consider any candidate's or employee's race, even if the intention is to create a more diverse, equitable, or inclusive workforce in any employment decision outside the very narrow context of permissible affirmative action programs. So it's always been the case that employers can't create hiring quotas, reserve seats for employees from certain groups, even in the interest of diversity. But in my experience, most workplace DEI programs, especially those that are developed with the assistance of counselors, experts or counsel, don't include quotas or a thumb on the scale in favor of protected characteristics. They don't rectify disparities in representation by supporting reverse discrimination, that is, giving marginalized groups preferential treatment. Instead, most proper DEI programs really seek to remove obstacles and barriers and create opportunity for all employees by, increasing the candidate pool, implementing things like blind hiring procedures, not consulting social media before offers are made, different kinds of things like that, expanding the kinds of recruiters, the geographic areas, the schools you recruit from, really focusing on the candidate pool and other issues to try and increase representation. And I really do think it's a means to an end sort of inquiry. I think, properly acquiring data on representation in the workplace is still okay. And I think it's something that needs to be done to properly develop a DEI program. And I think you can consult those numbers to mark progress, but it's the means to the end, and it's the steps that an employer takes for purposes of increasing representation that I think is really where the focus is.
So one of the ways that I try to message this to people that come to me with that question to say, look, an anti-discrimination program is different from an affirmative action program. And sometimes you can achieve essentially all you want to achieve using anti-discrimination language, right, without going to affirmative action language. And if you stay with anti-discrimination, you're much more likely to be out of the woods and not in trouble, even post these opinions, than if you use affirmative action language, even if both of them get you to precisely the same place. Is that reasonable?
I think that's absolutely correct. It's not using race or gender or another protected characteristic as a consideration for hiring or promotions or compensation. But it is, as I said, removing the obstacles to opportunity, removing discriminatory barriers that I think is the way to achieve the result.
Pam, you are a student of the Supreme Court in a way that very, very few other people are. I just want to brag on Pam for a second. Pam and her law school clinic, they are probably among the most successful Supreme Court litigators in this whole country. You can stack Pam up against the most expensive law firms, and Pam is going to win. She's going to crush them every time. As you look at this situation from your perch, Pam, what does it look like to you, and how do you see this playing out in terms of litigation that might be fomenting anti-discrimination, affirmative action, the kinds of test cases that some people might want to bring in this space?
Sure. So first of all, thanks for having me. I think Marina's point about the pool is absolutely right. And your point about anti-discrimination, which is another way of thinking about this, is wholesale versus retail. That if what you're doing is kind of wholesale changes, that is trying to change the pool through recruiting and the like, using diversity messages inside the firm and the like, you're not going to have problems. Where the problems come are when you have a particular individual who claims, I was not given the job because you preferred somebody else on account of their race. And that's going to be true whether that is a person of color or a woman claiming that a white person or a man got the job, or it's a white man claiming that he would have gotten the job, but it was given to a woman of color instead. That's where you're going to see the litigation. And most of the litigation, if the last 30 years of Title VII cases are any indication, most of the litigation is going to come from people already inside an organization who aren't getting a promotion or who are being fired. It's not as likely to come from people outside the organization, simply because they have less human capital invested in a particular job inside. So I think where you're going to see this is middle level managers who don't get promoted and claim that their promotion went to somebody else because of a sub rosa affirmative action plan or the like.
Right. So what you're seeing is the highest likelihood of litigation is in the one-on-one situations from within the corporation where somebody gets promoted. Typically say a white guy does not get promoted and a Black woman does get promoted. And how do you think that would then play out? What kind of evidence do you think the courts would look for? And how do corporations stay away from that, the thorniest of positions?
Well, I haven't advised corporations on this from the inside, but I have advised legislatures in dealing with redistricting. And one of the things we always have said to them is, don't write it if you can say it, don't say it if you can think it, and try to avoid thinking it. And so, the kinds of cases that are going to be most powerful in the courts are ones where the plaintiff can come in with some smoking gun documentary evidence. And so people should avoid saying, I'm going with candidate A because we've never had a Black woman in this position before. Instead, talk about candidate A's qualifications and why you think she'll do a better job than the alternative candidates.
Can I ask a question though, Joe? Because I feel like what Pam just said goes a little bit to Chief Justice Roberts' comment about admissions essays, right? Because what it basically gets to is this notion that if you are a person of color, I think you run the risk that I can't talk about who I am and my identity, because if I talk about that openly and it is discussed in an interview or somebody references the fact that, that somehow becomes proof down the road if you get the job and somebody else doesn't get the job, that it was because of your race that you got the job. And I think that's what I worry about, is that the decision will create an assumption that if there is a person of color that gets a job and the person who doesn't get the job is white, particularly if they're a white man, that people just assume that, well, it must have been because the employer took that person's race into account. And the chilling effect of that, I think, has the potential to be real.
And then let's assume that that's the case. How would you counsel and advise corporations to avoid that problem?
Well, I mean, having worked inside and advised a lot of corporations, I think, the advice that Pam gave, I think, is the right advice. What I would say is my experience, and I'd be interested in Christina's perspective on this. Whenever you're talking about race in a business context, most people are super uncomfortable about it to begin with. And so I think part of the debate and discussion that's happened in the last 4 years is people getting more comfortable in the nuance of talking about these issues. And I think this is going to be an additional accelerant in the need for people to understand how to talk about issues of inclusion and race and diversity in a more thoughtful way.
So let's go back to another hypothetical that I used earlier on, and let me ask you, David and Pam and everyone else to chip in. Suppose there's a corporation. They know that they have 5% of middle management being Black, and there's a document that says we'd like to get that number to 10% within the next 5 years. How problematic is that? Pam?
Well, some of how problematic it is depends on what the labor pool is. That is, if you have a labor pool that's 15% Black and you're only at 5%, then you have reason to worry that you have Title VII liability for a classic disparate impact or disparate treatment case, and saying we need to do something about this because there's this huge gap is not, I think, going to cause you problems, because it's clear what you're trying to do is avoid a Title VII liability. If, on the other hand, the pool of people that you claim to be looking at is 6% Black, and you say you want to get to 10% Black, using those numbers puts you, I think, at some risk. And so that's why I go back to the thing Marina was leading off with, which is figure out whether you have artificially constricted your pool in some way. That is, if you're only looking at people from 7 schools, you may have problems, and you may have more problems down the road if those schools cease to be as diverse as they now are, because of the SFFA decision. So ask yourself, why is it that we've only been recruiting from these schools? Are these the schools that are only people from these schools qualified for this job? Or are there people from other schools who are equally qualified, schools that might have a more diverse pipeline? So you have to ask what the pool looks like before figuring out whether saying we need to increase our representation is a problem or not a problem.
Yeah, no, I think that's exactly right. I think contextualizing many of these situations is extraordinarily important. And the way Pam just put it is, if you say, wait a minute, the right number in terms of representation is 10%, we're only at 5%, then it becomes very easy to describe what the corporation is doing as anti-discrimination rather than affirmative action. You start saying, well, gee, more than 10%, then it starts looking like something other than anti-discrimination. And you then are standing up in the foxhole and you're opening yourself up to additional potential claims and the like. And again, I think that's extraordinarily important to get the denominator right in many of these situations.
I guess in practice, like I think what David is suggesting and what Pam is suggesting is what lots of good HR teams and lots of corporations that are thoughtful are usually doing, which is looking at available talent pool. And I guess there's just a baseline there that in a corporation, as you pursue D&I efforts, it makes sense to first to start with some of that data and really try and understand your landscape instead of moving forward sort of more quickly without that context. And then just to push on one thing David said, which I think is important, and for me felt like a parallel to the admissions essay example. I think that in talking with candidates, really focusing on who brings diverse perspectives or whose experiences are bringing something else to the corporation, which could help you, speak to more diverse customer bases, to figure out things in a way that you haven't before. All of those things still feel like important discussions you can have without running afoul of these issues and without being so dogmatic about the question of race in such a specific way.
Now, here's what I think is fascinating. The takeaway that I get from this conversation is the vast majority of well-counseled corporations should be able to continue doing what they're doing in the affirmative action DEI space, perhaps with some wordsmithing, right, to make sure that you're using the appropriate words. And in the real world, not much will have to change. I think that's the major message in terms of counseling around the affirmative action cases. But when it comes to religion, I see the world totally differently. I see Groff versus DeJoy as potentially creating unlimited number of real world problems, some of which are like hypos from hell, right? We don't know how to counsel people about this. And the Supreme Court has now opened up a can of, I hate to say it, godlike worms, right? Who the hell knows where this goes? And here there will be real change on the ground, and the effects will be very substantial. And to me, it's fascinating that everybody's focusing on the affirmative action cases when the real action, in my view, is in the religion case. Let's kick this off, all right? And Marina, could you just take a moment or two, summarize what this opinion's about and why it's going to create hell for many employers in many situations?
Absolutely. So the U.S. Supreme Court ruled unanimously in favor of a former U.S. Postal Service driver, Gerald Groff, an evangelical Christian mail carrier whose request to have Sundays off were rejected on the grounds that it created a scheduling hardship that frustrated his coworkers. Prior to this case, the Supreme Court had ruled in 1977 on religious accommodation cases and had set a standard where the standard for whether or not you had to grant a religious accommodation was de minimis hardship. So it was very difficult prior to this new case for employees to prevail in bringing cases challenging the denial of accommodation requests. And there was not much litigation in this area as a result. With this new Supreme Court case, the standard has drastically changed. The prior standard really favored employees, but the new one, employers. But the new one favors employees in this context. An employer now must approve religious accommodation requests unless doing so would impose a substantial increased cost in relation to the conduct of its particular business, which is much different than the prior de minimis standard. So it's much more difficult now for an employer to deny religious accommodation requests than it was in the past. And the biggest problem, as you were alluding, Joe, was that the court did not define what would meet the definition of a substantial cost. The percentage of religious discrimination cases brought before the EEOC has been something like 2 to 3%. But it's likely that requests for religious accommodations will increase in the workplace following this decision. And it'll take time and lots of litigation, I expect, to determine what burdens, what costs will meet the standard of a substantial increased cost. So we're looking for substantial increase in accommodation requests and litigation over this area and years really to flesh out what this standard means.
Well, let me just sort of expand on it a little bit, because technically, if I recall, the language in Title VII is not cost, it's undue hardship on the conduct of employer's business. And increased cost is one element. But one of the open questions is, even if cost is not increased, if it, for some reason, creates issues with other workers, even if there is no, is that also a hardship? What does a hardship mean? How is a hardship different from a cost, and what have you? So let me sort of, kick off our conversation by asking people, what kind of questions are you getting? What kind of questions do you anticipate around this? And how do you advise and counsel people to deal with this situation where we have a totally new standard? Employees now have powerful incentives to claim religious practices that require accommodation, to argue that accommodating me is not a substantial hardship. Where do we go with all of this? All right, Marina, let's keep the ball with you for a moment. What are you expecting? What are some of your hypos from hell in this situation?
I think, we'll see a lot of these cases, at least initially, in the context of businesses that operate on a 7-day per week schedule or that require weekend work. And I think, just like in the foundation for this case, you'll see people who ask for Sundays off for purposes of religious observance. And an employer who grants that request will have to ask another employee to fill in on Sundays or to work on Sundays more often. And that will create morale issues and discontent, probably among the employees who are now being asked to take on more weekend work. Now, that in turn may cause those employees to make a request for Sundays off on the basis of their sincerely held religious belief. A smaller business could find itself in short order of getting to the point of not having enough labor to cover weekend shifts. They may need to hire new part-time employees to staff the business on Sundays. And the question will become, can the employer deny requests for Sundays off when it reaches the point of not being able to staff the business on Sundays? Does that mean that employees who make their requests later can have them denied on the basis of a substantial hardship in relation to the conduct of that particular business? Can the employer then reevaluate all of the requests for Sundays off for religious accommodations? Judge Sotomayor stated in her write-up that some hardships, such as the labor costs of coordinating voluntary shift swaps, are not undue because they are too insubstantial. So if that's the case, when does the scale tip to a substantial hardship in relation to the conduct of a particular business? Is it enough for an employer to show a material impact on employee retention and recruitment. And so I think we'll start to see the fact pattern first, I believe, with request to the request for Sundays off.
So Christina, this is all hypothetical, all right, when Marina's talking about it, but it's the world you're going to live in. What does it look like from your perspective?
Yes, well, you've made it so colorful, like this fire and brimstone, hypos from hell, that in preparation for this discussion, I asked around, because, as said, I lead HR at Instacart. We're in the business of delivering groceries,
24/7.
certainly 7 days a week, all different hours, and we have employees throughout the country and in all different walks of life doing different things for us. And so I went and tried to find out, like, sort of where there might be rub and where we might see these issues. To date, we have, currently we already provide sort of access for time for prayer if people want it. And we allow people to choose who don't want to deliver certain items because it conflicts with their religious beliefs. Because we deliver like from drugstores and pharmacies. So if people don't believe in contraception, they can turn down an order. But besides that, we have had very little issues of folks wanting to take the time off. So, I mean, maybe we're opening up this, can of proverbial worms by talking about it. But sorry.
You're a very different kind of business. You're basically running a gig economy. And if somebody doesn't want to work on a Sunday, they just don't volunteer on a Sunday.
Yes, but those are shoppers. On any given day, we might have 600,000 shoppers who are gig workers. That's not who I'm talking about. We also have thousands of employees who are W-2 employees who still may facilitate the stacking and launching and packing of groceries in various different ways. So I'm just talking about our employees, because yes, a shopper who does work for us, but not as an employee, as a 1099 contractor, they could just choose not to take a batch on their Sabbath.
Right. And what's interesting, Christina, is you're pointing out another prediction I would make as an economist, and that is people who want religious accommodations are going to gravitate towards larger employers, where the larger employer is going to encounter a less substantial hardship, all right, because it's easier to find somebody else to fill in. So
yeah, definitely. I mean, well, for example, Amazon, I would imagine it would be much harder for them to show a substantial, a substantial impact versus little old Instacart.
I'm thinking about the local pizzeria that needs to hire a delivery driver, as opposed to Amazon that needs to hire a delivery driver. Right? If this delivery person doesn't want to work on Sunday, and Sunday's the busy day for pizza delivery, all right, well, then you got a problem with the local pizzeria, because he's got to find somebody to fill in for Sundays when he needs all hands. Whereas Amazon, okay, fine, I got another 800 million people who will be able to fill in on Sunday.
Give or take.
Give or take. David, what does it look like from your corner?
Well, I would echo what you said at the top of the call, which is I have yet to have a client or anybody ask me about the case. So, and I don't know whether that's because it's not on people's radar the way it is for folks who, follow kind of religious freedom cases. But I guess a couple of reflections. When I worked for Senator Kennedy as his general counsel on the Judiciary Committee, one of the main pieces of legislation that I worked on was the Religious Freedom Restoration Act. And, I was struck as I got more familiar with this case, one of the dynamic tensions that was always at play when we were dealing with that kind of legislation was this balance between religious freedom and civil rights. And that always came down to the nub at the end is, have we gotten that balance right? And what I'm struck by right now is the combination of the affirmative action case, the as people have referred to it, the website case for the gay couple, which sounds like it was maybe just a made up case. And then this case, And it starts to feel like that balance is tipping in a particular direction. And so I'm intrigued by the interplay of all of these cases, and the cultural issues, because of the fact that we live in a society now, unfortunately, where oftentimes religion and civil rights and equity are pitted against each other. And the scenarios that I worry about are circumstances where someone who has a sincere religious belief or claims to have a sincere religious belief doesn't want to work or do something to support a customer or somebody who happens to be gay because they don't believe in gay marriage or the like. And it just feels to me, to your point, there's a lot of complexity that I'm not sure, and I know the court, Pam knows this better than me. It's not like they think about the interplay of all these cases, but it feels like maybe they should have thought about the interplay of all these cases.
I love the way you're framing this, and we can go back to a point that Christina made, where what they do is they say to certain of their drivers, you don't have to deliver, certain birth control pills, all right, or morning after pills or what have you, if that's, against your religion. And that raises all sorts of impossible questions. And whenever I have an impossible question, I always visit Pam. So, for example, how do you test the sincerity of somebody's religious belief? I mean, suppose you're a devout Catholic. Is it a violation of your Catholicism to deliver a drug that you haven't prescribed? Is there an obligation on the part of Instacart to let the person know what it is they're delivering? Isn't it enough to say, pick it up at the pharmacy and deliver it? It's none of your business what it's for. And then how do you test the authenticity of a religious belief? Somebody says, look, I don't, Sunday is my day of rest. All right, so I don't work on Sundays. Well, how do you test which religion are they a member of? Is it really part of that religion? Where do we go with all of this?
Well, the starting point is that it's not a question of what religion do they belong to or what does that religion believe. It's about what do they believe their religion requires. And so you don't ask, well, is this the official dogma of the Church of the Flying Spaghetti or whatever church they claim to belong to? You ask, what do they sincerely believe? And it's a subjective inquiry. It's about what do they believe. And in the example that you gave, one of the problems is a question about complicity. And that goes also to David's hypothetical. So imagine that you're the small business, you're a florist, and you have one employee in the shop, and that employee doesn't want to do flower arrangements for a same-sex wedding. Do you have to hire a second employee to do that? It's unclear from the way the Supreme Court wrote its opinion, because among other things, and this goes back to something that Marina was saying earlier, they don't tell you what it means to talk about substantial in the context of this employer's business, except to drop a footnote making fun of Walmart for refusing to spend time looking for voluntary shift transfers for a manager who didn't want to work, I believe it was on Saturday. Well, that suggests that there's something about the company that's relevant. Then there's this question of whether employee morale counts, because the court says you can't refuse to make an accommodation on the ground that other employees will be upset at you for making religious accommodations. On the other hand, if the employees are upset because they're forced to work on a day that they also think is important, or they're forced to accommodate another employee's beliefs on an issue that's important to them, you may end up with conflicting employees. I mean, that was a little bit of David's point, that you have on the one hand, a female employee who says it's important for me to be able to go to my kid's school play, and a Muslim employee who says, but I can't work on Friday afternoon. And then how are you supposed to balance these? The court does seem to be leaning quite a bit these days towards accommodating religion, even if that means circumscribing anti-discrimination provisions in some way. That's certainly the message from 303 Creative.
Right, and I think that's also consistent with David's concern So let's try to come up with some of the most difficult hypotheticals that are troubling. And I think you're scratching right at them, Pam. It would be situations where someone claims an authentic religious belief and position that infringes on someone else's civil liberties, civil rights, or someone else's religious belief and prescription.
Yeah, I'll give you an example. I'll give you an example that's drawn from a real case here, which is you have a transgender employee and you have an employee who says, my religious belief is that you are whatever sex you were assigned at birth, and therefore I will not use Mr. to refer to this transgender man because I consider this person to be a woman. There you have one person who says, I want an accommodation, which is that I not have to refer to this person by an honorific that I can consider them not to have as a matter of my deeply held religious belief. And you have another person who says it's sex discrimination for the employer not to treat me the way he treats every other man. And the fact that I'm a transgender man rather than a cisgender man is irrelevant.
And how will the Supreme Court decide that case? What's your prediction?
My prediction is they will strain mightily to come up with some way of avoiding having to decide the case. And one of the things is the Supreme Court can avoid the case by just not taking the issue.
Correct.
What's going to happen in the lower courts, they've come out in different ways on these cases before Groff against DeJoy came down. So there was a case in the Seventh Circuit where a school teacher refused to call transgender children by the names they were currently using.
Right.
He ultimately quit and then brought essentially a constructive discharge case, and he lost. On the other hand, there was a case in the Sixth Circuit where a professor refused to call a transgender student by her preferred honorific. And the Sixth Circuit, I think, treated that as if it were the First Amendment right of the professor not to have to use words he thought went against his strongly held religious beliefs.
So I think you're absolutely right. And there's certain circuits in which the outcome will depend upon which is the panel, all right, that's called upon to decide the case. But let me not let you wiggle out, if I may, Professor Carlin. Suppose the Supreme Court takes the case with the court as currently configured. And by the way, I'm going to ask everyone else on the panel to come up with their prediction as well. What is your prediction as to how this court would come out?
See, I can't really give you a prediction on it because so much of it would depend on the facts. So, for example, in hostile environment cases, it has to be sufficiently severe and pervasive. So one question is whether the court would treat one or two times misgendering somebody as sufficiently severe and pervasive to constitute sex discrimination. If it's a manager, I think it's much more likely that the corporation will lose if somebody's manager refuses, continuously misgenders them and claims to have a religious basis for doing that, than if it's a coworker. So, I hate to say this, but on a huge number of these questions, it really depends quite a bit on the facts that get up to the court. Even though theoretically the court is giving you an answer to a question of law, how they come out on that often has a lot to do with the facts of the particular case they take.
So it's interesting. I'll dive in now so that all the other panelists will feel comfortable. I'm not going to pussyfoot around it. I'm going to say that this Supreme Court, the way it's currently constituted, will privilege the right of the person claiming the religious belief, and will say the number of times in your relationship to other people can't constrain your ability to express your vision of what God expects of you in any way, shape, manner, fashion, or form. So in other words, this court will reject the proposition that your ability to not call a transgender person by their desired honorific is somehow diminished because you're a supervisor rather than a coworker. That's my prediction about how this court thinks about religion. And it's because my general view is they have a much more fundamentalist view about the protection of religion in the Constitution, First Amendment, that has historically been the case. Let me ask you, Marina, how would you look at this predictive issue?
I think in a situation where accommodating an employee's religious beliefs or expression conflicts with, comes up against treating other employees fairly. In other words, if it requires discrimination against another employee as opposed to clientele or customers, I actually think that the court would find that would satisfy the substantial hardship standard. Because it can't be that an employer is in a position where they need to violate the rights of other employees in order to accommodate a sincerely held religious belief or expression. That's my view. I think that's where you'd meet the standard.
David, what do you think?
I'm torn. I mean, I'd like to believe that Marina is right, but I just, it feels to me like we have moved to a place where, and I don't say this with judgment. I'm just that there's a little bit of a get out of jail for free pass in terms of the perception as to, if you have a sincerely held religious belief, there's certain things that, you know, are now just kind of allowed. And if it means that somebody else's civil rights kind of are trampled in some way, shape, or form, then there is a little bit of a prioritization, and which is why I think the question that you asked Pam about this, how do you measure sincerely held religious beliefs, or how do you judge that? And the fact that it really is totally subjective. I think that's the part that for people who are concerned about the balance between religious freedom and the protection of other rights, if it is totally subjective, that's where I think it makes people feel like, if you have the weight of the Supreme Court on the side of subjective, that feels, at least for me, like things are a little bit out of whack. But that's just my personal point of view.
Christina, at Instacart, how do you see these issues? And what would happen if a supervisor said, my religion basically says I can't respect a transgender person's desire with regard to the honorific?
I think that'd be a real problem for us in terms of like the citizenship of the company and how we interact as a culture. In terms of, you know, how the Supreme Court might come out at it, I really would hope that Marina's right. But the unanimous ruling in Groff doesn't give me a lot of optimism about it.
Right. And so what would happen as a practical matter? So here's the hypo from hell. All right. You've got a supervisor. The supervisor is of a faith and honestly believes that there's something really profoundly wrong about transgender people, and expresses that view by saying, I'm not going to use the his, her, they, them, whatever it is that they want. All right. I'm calling him, you know, Mr. because he was originally a Mr. That was his, you know, that was his birth sex. All right. What then do you do? What do you do?
I think right now in the company that would be something that we would hopefully sort of address in a pretty direct way early on, as someone is getting acclimatized to the company, that maybe this wouldn't be the best fit for them. I'm gonna punt on exactly what we would do, but
my sense is that a lot of companies,
punting is the right answer.
Yeah,
I'm going to respect your punt.
Yeah.
Speaking of respecting the punt, I'm going to punt it over to Kristen right now, who has a bunch of questions for the panel. So Kristen, the punt is to you. Feel free to take it back for a touchdown.
Great. Thank you so much. Let me just pull up these questions. Going back to the affirmative action cases for a moment, there was another hypo from hell posed. What if a company has a stated goal that 50% of its hiring candidate pool is diverse? Is this a problem after the Supreme Court's new ruling? And Pam, maybe that goes to you. So there was a lot of focus on the hiring pool, but now the question is around if there's some kind of quota or stated goal within that hiring pool, does that pose a problem?
So you never want to have a quota, and you never want to say you have a quota, because that's the kind of third rail word. I think saying a number, if you can avoid it, is a good thing to do, because the more that you're using a kind of blunt number, the more likely it is that a court reviewing something is going to think that what you have is essentially a quota. So I think I would avoid saying that. I'm not sure from the way you posed the question, if the issue is you've got a diverse pool and now you're saying we want 50% of those people, the people we hire, to be traditionally underrepresented, coming from traditionally underrepresented groups. Is that what you're asking? I just want to make sure I'm getting the question correct.
I'm not entirely sure what the person was getting at. I would assume, yes, if you're looking at the potential candidates, so you're looking at your.
Well, if you have a diverse pool of qualified candidates and you are using a fair selection process, that should produce a diverse result. So I guess the thing is, first you want to ask, what are we doing to get a diverse pool? And second, what are the criteria we're using to winnow down that pool to the people we hire or the people we promote or the like? And if you've solved both of those problems, you shouldn't need to do something on top of that. That should produce the results.
I may be wrong. I think the person may have been asking, because we were talking about looking at the addressable market. If let's say the addressable market was just 15% Black, but you said we have a target to have a pool of 50%, would that be problematic? I think that.
Yeah, I understand the question the way David did, and let me make it more concrete. There are organizations that have summer internship programs where the internship programs are dramatically overrepresented by minorities and women. And they run these programs because they are underrepresented in minorities and women in terms of permanent hires. And they're using this as a way to find talent for permanent hires that they would otherwise miss. So if an organization is running a summer intern program where the vast majority of the interns are non-white male, and they say, we're doing this because we need to find the talent in order to eliminate, historical imbalances, is that problematic?
I think that's an area where you may well see lawsuits. And the reason for that is that people who are not yet in an industry, and then the people who are already inside a company, are the ones I think who are most likely to want to bring suit, as opposed to people who are working at a competitor or a peer firm and are thinking about moving. And the folks who are going for these internships are the same kinds of people who have been the litigants in the affirmative action cases in front of the Supreme Court. So I would expect that, if the sort of SFFA folks are looking for the next frontier, it will be something like an elite firm that has a summer internship program in which all of the interns are members of traditionally underrepresented groups. That's where
it's basically what the America First Foundation, it's basically the letter they sent to BlackRock about their internship program.
I think that's right. I think this is one of the areas where, if you had to predict, there are large organizations, and it's all publicly known, that do have these internship programs where there's significant overrepresentation of minorities. That, it seems to me, that's an area where you have a higher index of concern. Kristen, you've got some more questions, I suppose.
One more question. There was a letter that went out recently from Republican attorneys general to the heads of Fortune 100 companies, and people are curious what impact that will have on I suppose the understanding that we've sort of come to from this webinar, that well-counseled corporations may continue with their efforts to support diversity. So maybe we can talk a little bit about the letter, what it says, and what the intended impact will be. or what the intended impact was and what the actual impact will be.
There was a Democratic response letter from, I think, a slightly larger number of AGs. So I'd be interested in Christina's take on this. I mean, I think the people I talked to thought it was a bit of political theater. I mean, it didn't go to any particular company. It just was kind of an open letter to, Fortune 100 CEOs. I think people who have large employee footprints or offices in some of those states will probably be taking a slightly finer tooth comb to some of their programs and initiatives like we talked about. Whereas people who are operating in states, it reminds me a little bit of what happened with, the College Board African-American history, where you got a couple of AGs on one side and then the other AGs on the other side, or what happened to, Walgreens with the morning after pill. I think it's just unfortunately the reality of operating in the corporate world right now. There's that image of Jean-Claude Van Damme where the buses are going apart and he kind of drops below vertical. I feel like that's kind of the American corporation right now, trying to balance, but I'm interested in Christina's view on that.
I can't speak for my whole corporation, but I'm not especially troubled by the letter. It seems like it's political theater to me entirely.
But here's the problem in a certain sense. Political theater is real theater. And I've got a theory that the corporation is the new piñata in American corporate politics, that it winds up getting bashed from the left and from the right. And whenever anybody's got a reasonable political incentive to try to make some kind of social point, you go look for a corporation and you just swing your stick at that piñata. And, I spend a lot of time with the piñata. All right. I spend a lot of time with, the poor CEOs and the corporate directors, and they go, hey, Grenfest, what am I going to do about this? And my advice more often than not these days is something along the lines of suck it up. You're the piñata. All right. And there's nothing the piñata can do about the people with the sticks. Be polite. All right. And the beating will stop in a few moments and they'll move on and they'll hit a different piñata. And that, unfortunately, is the advice that you often wind up giving, and it winds up sticking. All right, people understand this is political theater. It makes you very uncomfortable. The worst thing you can do is respond by trying to strike back. You're angry. I get it. Take a chill pill. And what other advice? What else is anybody seeing or saying around this, Marina?
I think you're exactly right. There's not much to do but to just sort of let it pass, wait and let it pass. I think the natural inclination, especially of some CEOs and other executives, is to take a stand, to make statements, to react. And our counsel is always not to do that and not to engage. I think it prolongs, it continues the bashing, it might lead to other bashing. But I, many of our clients too are corporations, corporate defendants, and we find ourselves having similar discussions.
So we're at the end of time. We're going to close with one of my favorite quotes and stories. There's an episode in The Crown in the most recent season. It's called Annus Horribilis, where Elizabeth winds up giving this speech about 1992, which was a terrible year. And the Queen Mother is strongly opposed to Elizabeth giving this speech. And the Queen Mother comes to Elizabeth, and these lead to what I call the Queen Mother rules for CEOs speaking on political matters. And I've actually given this advice to CEOs and they love it. The Queen Mother asks the CEO, first, must this be said? Is this something that really needs to be said? Second, does this need to be said now? All right. If you think it has to be said, you should just let the moment pass. You need to speak up. And third, does this need to be said by you? All right. Maybe there's a message. Maybe the corporation should send a message. Maybe it should even be now. But is the CEO the right person? How do we send that message out? And in many of these situations, if you just take a step back and you sit with the CEO and you say, look, we're going to go through the Queen Mother rules. Does this really need to be said? And if so, what do you need to say? Do you need to say this now? And are you the right person to say it? It's fascinating how that disentangles a lot of the emotion and sort of diffuses the situation because people see other alternatives. Now, there are situations where that doesn't happen. And I'm specifically thinking of Ken Frazier at Merck after Charlottesville. You go through the Queen Mother questions, you got to do what you do. Absolutely, no doubt about that. But there are many other situations where the answer comes out differently. Kristen, balls to you.
Great. Thanks so much, Joe, Pam, David, Christina, and Marina for sharing your time and your insights with us today. And thanks to everyone in the audience for joining us. I hope you all have a wonderful day.